So if there's one thing you take away from today, don't use the B word. Breach is bad. We don't like it. So if you've noticed, I've been using it this morning. I use the term incident, or I use the term event. Take that practice back with you. So the word breach is used too frequently, and regulators don't like it. It suggests that something bad has happened, and in many cases after your investigation, you prove later that in fact it's not a breach. And worse, it actually has legal significance in some jurisdictions. So you never want to memorialize the word breach in an email, in a voicemail, in a text message, in a written document. Tell your teams not to do that. Call it an incident, call it an event. I'm taking note and lesson from our fellow IT professionals. That's how they refer to things. So you should do the same. Do not refer to the event as a breach, because it could come back to bite you from a regulator. So let's talk a little bit on the federal level first. So HIPAA high-tech, yes, for any of the healthcare folks in the room, I'm expecting the tomatoes thrown at me because I already know they've been dealing with this for many, many years. But I bring it up because some of you might be a business associate to a covered entity under HIPAA high-tech. So in other words, you're a vendor, you're a third party that services a hospital, a healthcare organization. If you are, and you will know if you've signed a so-called BAA, as they're called, a business associate agreement, you need to be mindful. You may not be a healthcare entity, but you service a healthcare entity. As a business associate, you must comply with HIPAA high-tech. And guess what else? Regrettably, as of September 23rd, a few weeks ago, you are now invited to the regulatory party, which means the Office of Civil Rights and Health and Human Services now has the authority to investigate you and ultimately potentially fine you. So do recognize if you are a business associate, and yes, if you're not a hospital, I get it, but if you are a BA, you now face HIPAA high-tech fines and investigations as well. And if you don't think that cannot happen to you, like you think, oh, OCR is too busy chasing hospital breaches, this was the whole point of why they have now enacted that business associates are under regulatory scrutiny too, is because Mr. Rodriguez, who is the Director of Office of Civil Rights up in Washington, he has made it very clear he wants to get more money. And he's getting sort of tired of the public outlash of providing million-dollar fines to a hospital that's really there to take care of the community, and the community is hurting if they're fined by those kinds of numbers. But he has no problem going to the non-healthcare entities that are servicing them and fining them. So this was all, don't think that this was accidental or unintentional. There's a whole strategy as to why the omnibus final rule, the amendment that got changed last month, came into play.
And Alex, I have a case in point to add. I was on a phone call just before we started with one of our claims managers, and she was speaking to me about an account that I underwrite on the E&O side. They're a business associate. The business associate has a claim that's ongoing, thanks to a breach that happened last summer. And funny enough, the regulators have since opened up an investigation, exactly to your point, under a breach of HIPAA high-tech, about whether my insured did a good job and appropriately notified according to the state laws and according to HIPAA high-tech. And so they're now being drawn to the mat, and it didn't take them long to get going. So it's happening, and it's happening to the point where they're going back and questioning prior acts, if you will. And that's what's making me even more nervous as an underwriter. But hey, I'm here to take risks, so that's what I do.
Thanks, Max. Also recognize the other thing that has changed with the amendment to HIPAA high-tech that went into effect last month. They've now changed sort of the process of the risk of harm analysis, or the investigative practice, where before last month, you were innocent until proven guilty, meaning you had to investigate and prove you had a high probability of risk of a breach in order to mandate notification. Office of Civil Rights literally did an about-face on that. You're now guilty until proven innocent. That means you have to presume you have a breach, and it's your job to prove that you have a low probability of risk. So what does that translate into? That tells me you're likely to face a more frequency, if you will, of investigation work. And those cost money. There's costs there. And yes, there's insurance that will cover those investigation costs. But that's something to be mindful of, is that you may have an increase of frequency of investigation services needed for when these events occur. If you accept transactional data, it's the fancy phrase for credit cards. So if you accept credit card data, you accept credit cards in your business, you obviously are probably having a merchant services agreement with some bank, your merchant bank that is, and you are likely being asked to comply with the payment card industry data security standards, or PCI DSS. Be mindful, you may accept credit cards, you have a bank and they have an agreement with you, and many times I have retailers or organizations that take credit cards that assume that if we had a breach of credit card data, I don't have to worry about it. It's on my payment processor. It's on the bank. They have it. It's in my contract, I swear. I would ask you to review your merchant services agreement. You probably have indemnification language, which is good. But guess what? The legal obligation of the response of that still is put on you. You are still the data owner. So I'll give you an example. I, this morning, went to Starbucks, got my coffee, gave my credit card to the nice lady behind the counter with the green apron. I have no knowledge of who Starbucks uses to process credit cards. I don't know their business model. I don't know what business decision they made to handle credit card processing. All I know is, as a consumer, I went in, bought my coffee, gave them my credit card. If there's a breach of that credit card data, as far as the consumer is concerned, I gave it to Starbucks. It's the same model to whatever respective business is here that has that similar process with credit cards. The consumer does not know who you have retained to do the processing. That makes you the data owner. You are that so-called initial collection point. So under the law, you are the data owner. If there's a breach, you probably have good language, I hope, indemnification in there. But at the end of the day, the regulators, the attorneys general, are going to look to you to see that you're meeting the deadlines to get notices out if necessary. So be mindful of that. Don't assume that you've removed that liability point just because you have a merchant services agreement in place. We talk about the red flags rule. If any of you are creditors, and forgive me, I know we can open up a very healthy debate here right now about who are creditors. Some industries have been trying to get out of being defined as a creditor to avoid the red flags rule amendment to FACTA, but some organizations and some industries are still viewed as creditors, typically hospitals, auto dealerships, if you will. Some medical practices could be viewed as a creditor. Anyone who extends credit. The one industry, as you can imagine, that got out of this was the legal industry. The American Bar Association fought hard and removed themselves as an industry class to be considered a creditor. But I don't know, other industries have done the same. You should check with your own counsel to see if you are or not. If you are viewed as a creditor, be mindful of the red flags rule, because that means you have to have a written data breach response plan, and you have to do privacy awareness training to your employees. If you don't do those and you're found in violation, FTC is coming down pretty hard lately on these events. So be mindful of that. I also bring up FACTA. Now I know we're here in Alabama, but if any of the organizations here have human resources representation in any of these states, just be mindful. I'm bringing this up because those states, they have state employment laws that say when you are interviewing a candidate to hire, until you offer them a job, you cannot pull a credit report on them. Why am I bringing this up? Because some organizations in those states still do that, and then they have the credit report stored in their files for a candidate they never hired. And guess what? As Murphy's Law has it, you have a data breach involving a breaking and entering into an HR office, and if you don't think those happen, they do. And lo and behold, through the investigation, you're going to have to admit to the regulator, the Attorney General, yeah, we had a breach involving credit reports on these individuals, and more often than not, the AG will ask, who are those individuals? Oh, well, some of them are candidates, some of them we hired. Right off the bat, you're now opening the door not to one, but to two investigations from the Attorney General. So please be mindful of making sure you don't hold personally identifiable data like credit reports when you're not supposed to. And in these particular cases, it's against the law. So just be mindful of that. If any of you are Federal contractors, I would have to believe in this area, some of you may be. Be mindful of FISMA. If you approach your IT team, many IT professionals are very well versed on FISMA, but also recognize there's some reporting obligations and some training obligations under FISMA. So you want to make sure that you're complying with this, because if you're ever found in violation, that's the last thing you need, is to have a federal regulator chasing you down because of a FISMA violation. And especially because being a federal contractor, it's even a more heightened and more sensitive position as an entity to take. And then we get down to this little unknown rule, and I want to bring it to your attention because we're starting to see a significant increase of these investigations. So the Federal Trade Commission has a rule called Section 5A. Section 5A is what's called the Unfair and Deceptive Practices section. So how does this apply to you? I would suspect every organization represented here has a public website. So if I go to your home page, and I scroll to the bottom, I'm going to find a link that says privacy policy. And if I click on it, with all due respect to every counsel in the room, I'm going to find 10 to 12 pages of the most exciting reading I want to do on a Friday night. What you're saying in your privacy policy is essentially, how are you using consumer data that you're collecting? How are you holding it? How long are you holding it? When do you dispose of it? How do you dispose of it? Do you share it for marketing purposes to third parties, and so on? The FTC is not necessarily concerned about what you say you do or not doing in that statement. What they do care about is whatever you say you're doing or not doing, you better be doing or not doing. If there's any inconsistencies to what you declare in that policy to what you're actually practicing and doing, the FTC defines that as unfair and deceptive to the consumer. Now, the FTC, a federal regulator, is in a little bit of competition with the Office of Civil Rights and Health and Human Services, who is the governing regulator for HIPAA high-tech. And the FTC is a little jealous that HIPAA high-tech is bringing in money to OCR. So the FTC, because we all know our federal government right now is ever so profitable, they're a little jealous. They want money too. So what they've now come up with is they are now riding the coattails of any publicized breach, and they're coming in to say, we understand publicly that you've announced you had a breach involving consumer data. We want to come in and investigate you for potential violations of Section 5A. So what does that mean? That means your privacy policies, you want to keep them as current as possible. Historically, I used to tell clients, maybe reviewing it once a year was good. I'm actually now advising clients to review it at least twice a year and ideally once a quarter. Once a quarter, your in-house counsel should review your privacy policy and make sure it matches to what your sales teams, your marketing groups, what everyone internally is doing with consumer data is accurate in there. Because at any point you have a breach, don't be alarmed when you find out that some analysts with the FTC in DC found out that you had a breach because you had to publicize it, you had to notify an attorney general who posted on their website, and now they send you a notice saying, oh, we see you notified the Attorney General of New Hampshire about a breach you had. We want to come in and investigate you for 5A violations on your privacy policy. They are really ramping this up. Now, the reason I'm concerned is because their judgments are pretty tough. The fines I've been seeing have been 6 to 7 figures. They're not small. And worse, their consent orders have been a rubber stamp for the last 8 to 10 years. 20 years. 20-year consent order. What does that mean? That means they have now the authority to come in and investigate your information security practices for the next 20 years. I don't think anybody here wants that. So please be mindful of your privacy policy you publicize, making sure it is as current as possible to avoid this potential liability. So we go to the state end. So we have 47 states, and as luck would have it, we're in the great state of Alabama. You're not one of those 47. So Alabama, New Mexico, and South Dakota are the 3 remaining states that do not have a state notification law. But a lot of you are saying, then why on earth are we here talking to you, Alex? You're a nice guy, but you know what? I have better things to do this morning. We have to talk about them because the laws of notification on the state level are defined based off of the residency of the person affected. It has nothing to do with where your organization is based. It has nothing to do with where the breach occurred. It has to do with the residency of the people you've breached. And as you can surmount, many of you may have customers that don't just reside in Alabama. If we think about higher ed, we think about universities, we think about hospitals, you think about a retailer who has visitors coming in and out of Montgomery, you're going to have people likely that live in other states. So that all of a sudden means, guess what? You have to follow those other state notification laws. You have to be mindful of how they notify, how are those laws drafted. And unfortunately, for those 47 states plus the few territories, those attorneys general, I wish for once those AGs went on a boondoggle cruise for a week and sat down around a table and came up with one unified law that works the same across all these states, but they didn't. So you have 47 opinions of what's a data breach, what's sensitive data, how many days to notify, what language goes in the letter, what other state agencies we have to notify. This is a huge tapestry of complexity. So if you have a breach of 10,000 people and those 10,000 people are represented in 23 states, guess what you're going to have to wind up doing? Breaking down those 10,000 people by state, and each of that class, subclass, has to be notified uniquely as to that state's law. There's no way around it. I've had many clients try to contest it, or at least just discussion, not actually legally contest it. And trust me, if you want to be the first entity to legally contest that jurisdictional authority argument, and if you don't want publicity, be prepared. You're about to get the biggest publicity you ever got, because that's going to be big privacy groundbreaking news. So you don't want to be that entity to challenge this, because rightfully so, that's how the laws are drafted. They're based off of the residency. So now you have to prepare letters differently from state to state. So some states say you have 5 days to notify, California. Florida reduced their law, they amended their notice law last month from 45 days to 30 days. Puerto Rico's a 15-day rule. Most of the states generally are 15 to 45 days. Now you also have language to consider. Well, I know how I'm going to draft the letter to these people, right, Alex? Some states are going to say, well, you have to say. Some states say you have to put explicitly what happened, what was the details of the breach. Well, guess what? Martha Coakley, the AG of Massachusetts, her law, she says she forbids that. She explicitly says you can't put any details of the breach in the notice. So you're sort of scratching your head like, well, then what do I say to a Massachusetts resident? This is the honest truth. If you ever see a notice to a Massachusetts resident, dear so-and-so, we had a breach of your information. If you have any questions, please contact us. It's almost that simple. There's additional language because they have requirements for credit freeze language and things like that. But the contents of it is literally like 2 sentences. And you're like, why on earth am I even going through this practice for this? That's just the way Martha wrote her law. So we have to comply with it. So it's really important to recognize this is an area of liability that can come up, because the last thing you need is one of those AGs is running for Senate or governor that year, and if you don't follow their law exactly, guess what they're going to ask you to do? They're going to say do over. Do it again. You messed up. I want you to send letters again. Remember what I said earlier, you have one shot to get the message out. You don't want to keep yourself in the news because you're not following the law correctly. So again, it's really important to recognize that. And then, as I said earlier, there's different triggers throughout these laws, so they're going to vary. And again, this is where the Privacy Council I mentioned earlier is really helpful, because he or she is going to know this, they're going to know this in their sleep, the strategy and how to do that. And that's how, again, you don't want to raise your liability because you didn't follow what the law required when you're going through that response phase, phase 3. We're not going to go into heavy detail here, but surprise, surprise, beyond our great country, there's also privacy laws. And you know what? They're tougher than what we have here. Privacy is viewed very differently outside the US. In the US, privacy is really from a basis of consumer protection. But privacy in Europe, in Latin America, in Asia Pacific, privacy is viewed as a fundamental human right. It's viewed a very different approach to what we have here in the States. So that means their laws are even tougher. And the last thing you want is to have a privacy commissioner, the equivalent of like an attorney general, say that you neglected to notify 100 residents of the United Kingdom because you're like, what can they do to me over here? Well, Christopher Graham, the privacy commissioner in the UK, can get in front of a mic just like an attorney general does, because they're elected officials. And they can be talking on how you, XYZ Incorporated, neglected to notify their residents. You don't want that. So you have to be mindful that those laws do apply to you as well. Just for point of reference, our two neighbors, Canada has 2 privacy federal laws, but none require notice. And they have the equivalent of state laws. There's 3 provinces, Ontario and Manitoba, and Alberta took a stay from their law, but it's going to be enacted in a few months. So they have the same requirements of notice like we do here in the States. Our neighbor south, Mexico, has a federal notification law. So any Mexican citizen must be notified in writing of a breach of their data. So again, this is just an example. There's 18 or 20 countries that have compulsory notice requirements as well. And again, we have to be mindful of them.